Hi, my name is Cullen and I'm a personal injury attorney in Winter Park, Florida. We meet with a lot of people who have been injured on the job. Most of the people that we talk to have been involved in car accidents while they're on the job, either traveling between job sites or something of that nature. But we also see people who've been injured by heavy equipment on the job site or a fall at a job site, just really kind of anything that happens in the course and scope of their work. Almost everybody that we meet with who has been injured on the job is already receiving workers' compensation benefits, and that's a good thing because that's what workers' compensation benefits are designed to do. However, workers' compensation has some limitations. Workers' comp only pays medical expenses and a fraction of the injured person's lost wages. It doesn't pay anything for pain and suffering. So many people come to us asking if they can still make a claim against the at-fault party for their pain and suffering, even if they're already receiving workers' compensation benefits. And the answer to that question is a little bit evasive, but the true answer to the question is it depends. And the reason that it depends is because of the way the workers' compensation law is written. So as long as the injured person is injured by somebody who doesn't work with them, isn't on the same job site, and isn't involved in the same project as they are, then it's usually a pretty simple matter. Well, not necessarily simple, because you still have to prove the elements of a personal injury case, but it's still feasible to collect a personal injury case. The classic example is, as I mentioned before, somebody who's moving from one place to another on their job. They're on the road, so they're in a company vehicle or maybe even in their personal vehicle, but they're really on a mission for their employer. If they're injured in a car accident by somebody they don't know or has nothing to do with them, then that's usually a pretty simple matter to make a third-party case against the at-fault driver. It becomes trickier when a person is injured on something like a job site, a construction job site, something like that. The way that the workers' compensation law is written, it's very difficult to make a claim against the employer or any of the fellow subs or any of the other independent contractors that might be on a job site if one of those people injures our potential client. The law requires a very, very heightened burden of proof, and so it's not impossible, but it's very difficult to make a recovery in a situation like that. If you have any questions regarding an on-the-job injury and whether or not you might have a claim against the person that injured you or the entity that injured you, please reach out to us. We are happy to answer questions. You can reach us by calling. It's 407-254-4901. You can text us at 407-644-4444, or you can even instant message us on Facebook.